Okay, we have a very exciting ruling that I'd like to talk about out of the Sixth Circuit, actually, the district court in the southeastern lower peninsula of Michigan specifically, but it is in the federal court system, and that's why it's very, very important in the Sixth Circuit. And the Sixth Circuit, of course, takes into account Michigan, Ohio, Kentucky, and Tennessee. In fact, I've got a map of all the circuits. If you're wondering where this actually takes place, these are all the circuits in the federal system. And there are 11 of them, I believe. There may be a 12th one that's off the screen, but I don't think so. I think that's mostly it, the 11th Circuit. Again, I'm not an attorney. I don't pretend like I am one, but I am somebody who reads a lot. And I do know a little bit about what I'm reading. What's really exciting about this particular case is that for the first time, the court declared that the registry and placement on a sex offender registry, whether it be for life or for just a few years, is punishment, which is really an extraordinary ruling and runs counter to the Smith v. Doe ruling of about 23 years ago in the U.S. Supreme Court, where current Chief Justice Roberts, in an earlier iteration, declared it not very important at all and hardly more onerous than a Price Club. I think he said Price Club, let's say Costco, if we want to update it for today, membership. And of course, this is just completely whackers and comes out of privilege and power of somebody who knows nothing about it, has never looked into it, and curiously has never bothered to actually interview anybody who's actually been on the registry. So they have absolutely no idea what people go through on the registry at all. I've talked about the registry a lot on my site, mainly because the stings, for example, are very much part of feeding the registry. And if you feed something too much, it gets bloated, whether by money or by power or influence or by numbers. And if you do not feed it, it starves, and it really deserves to be in the starve category at the moment. But I want to read to you this decision. I'm not going to read the whole thing. It's 15 pages and really comes out of several other iterations. What I'm reading here, or bits and pieces of it, is from the Judge Goldsmith's, who's a district court judge in the Eastern District of Michigan, which is the lower eastern side of the lower peninsula, in which he discusses the compromise that they have reached. And I call it a compromise because, remember, a judge has to balance competing interests. So what were the competing interests? Well, he had to judge the Department of Corrections and the state's need to protect citizens. Excuse me, with that of the constitutional protections that were being violated by people like me and by people, the plaintiffs in the Eastern District of Michigan. Now, the plaintiff districts are, excuse me, mostly John Does. There's one or two Jane Does, and of course they have to put it against the defendant who was the governor at the time, Gretchen Whitmer. I think she's still governor up there, and miscellaneous defendants like the Department of Corrections. So when I say plaintiffs, we're talking about those placed on the sex offender registry versus Whitmer and company et al., who are the defendants, the representatives of the state. I want to mention, too, that terminology comes in very important here. You notice how I say people placed on the registry, because you'll hear from trolls and others, sex offenders. Well, remember, you may have been placed on the sex offender registry for a variety of reasons. I pointed out that children are on there. I'm talking about people who have been caught urinating in the forest, or flashers or whatever. People who you might, say, well, it's a serious issue, but it's hardly the same as gang rape. And when you just say sex offender, that conjures up the very worst in people's minds, and which is the reason why the government and the police, etc., and prosecutors keep doing that. They want to make sure that you give them all the power by scaring you into thinking that everybody who's on there has committed some terrible, terrible crime. It is very easy to get on the sex offender registry. I've pointed that out in a wide variety of bits and pieces in my videos. Please watch them and really get informed. I'm not making excuses for people who did terrible things. I make that disclaimer again and again. I'll make the disclaimer that I'm not an attorney as I go in to talk about the very thoughtful decision that was stewarded by Mark Goldsmith, whom of course, I do not know, but I think it's very interesting. He goes into a very, in earlier decisions, he goes through some very interesting points where he gives a whole background, a whole understanding of where SORNA came from. And he talks about what he said when the plaintiffs say that it's punishment. He said the other side says they're just sour grapes and they're dirty, rotten sex offenders. Excuse me, in the previous decision late last fall in 2024. And he says, no, he says the plaintiffs have a point here. There is something that we can look at. So back to this, the first thing he starts with is definitions. And he will go to that later and he will say that the various groups, the plaintiffs and the defendants, have agreed they're going to redefine some politically charged terms. And why are we going to do that? Because those terms are offensive and non-descriptive, and they move us toward increased punishment when you've already paid your debt to society, you've paid restitution, whether it be in monetary or jail or prison or all three. And so why should you be on a registry for 10, 15, 20, 25 or life? And generally now it's between 10 or 15 on the lower tier, it's 25 or 20 on the middle tier, and it's life always without the possibility of removal on the upper tier. No matter how you want to skin it, most states are like that. So the court says, okay, well, I had to balance the challenges on ex post facto challenges. In other words, punishment after the punishment. I've been punished, just what I was saying. You paid restitution, did everything. I'm being punished even more afterwards, plaintiffs say. That's called ex post facto, from the Latin, from the thing after from the after time when the thing was done. Okay? Ex post facto. Afterwards, from the thing being done. So he says here that we're going to give the summary of judgment. We're going to give judgment without much, argument and debate and further briefing to plaintiffs on counts 1 and 2, which says that when the law changed in 2021, what the government did was take all of those people, if they were on a 10-year lower tier, 10 years having to register. Well, the law changed to 15. Well, then they moved you to 15. Now they move the goalpost. You're not on for 10, you're on for 15. That's an example of ex post facto, and it is actually what they're talking about here. And he said, yeah, that's not okay. And we're not going to allow that. He says, SORA, this is the sex offender regulations at the federal level, SORA iteration 2021 constitutes, I'm reading directly from the order, this is page 2 if you want to follow the judgment, page 2, I'll be posting it down below, point B2. SORA 2021 constitutes punishment and its provisions that retroactively increase the reporting requirements and retroactively extend the registration terms violate the ex post facto clause of the U.S. Constitution. That's really important. So this is what they have been doing repeatedly. They've done it to somebody I know who was in Kentucky, and when he was off the registry, he moved to Virginia. Virginia put him on the registry, even though he was off. And then he moved to he fought them and he got off of that. He moved to North Carolina to take care of ailing family, North Carolina. Again, put him on the registry, though he had been taken off. And they put him at a higher tier. And he had to fight to get off that. He had to fight being rearrested several times. He had to fight the fact that they were told by both Kentucky and Virginia that he was no longer on the registry, and instead they didn't care. They put him on again, and he got off, and then he was rearrested, okay, because of nothing new, but because, again, they revisited this and they decide ex post facto he should be on the registry, and there he sits again until he can mount another challenge, okay? This is the sort of thing they do all the time. The trolls, of course, will immediately say, well, he must have done something wrong. Well, he didn't, okay? And you can't keep punishing a man after you've already punished him and he's done his time for something that happened 30 years ago. Okay, so he also says, the judge also says, defendants, that's the state, they're stopped from requiring registration under any previous iteration as well. So they can't say, okay, well, we can't do 2021, so we'll force you to follow 2020's registration rules. Can't do that, okay? So within 60 days of this ruling, defendants are required to give notice to everybody in this same class of registrants that they are no longer subject to SORA and they have been removed from the registry. It doesn't give a mechanism. It says that the state must remove them. They don't have to go to the court and beg and plead. And say, no, the state has to do it. Okay? Individualized review, count 3. All right, so those were counts 1 and 2. Counts 3. Defendants, that's the state, is granted summary judgment on count 3. The plaintiffs, the registrants, had said, look, we're all individuals. And, the sex offender category is huge. We should be under individual review and for lengthy and lifetime registration requirements. They don't even look. They just say, they just sort us quickly into the various tiers. And the argument was it violated the due process clause of the Constitution and the equal protection clause of the U.S. Constitution. I won't go into those necessarily at this moment, but what that means is the defendants do not have to give individualized review. He says that's not reasonable. Count 4, unequal opportunity to petition for removal. Defendants, once again, the state, the governor and the staff, the parole board, the Department of Corrections, are granted summary judgment on count 4, which challenges similarly situated registrants' opportunities, I'm reading directly now, to petition for removal from the registry under the Equal Protection Clause. In other words, they wanted to be removed early, and he said, no, the state is okay putting 15, 25, and I think it's lifetime in Michigan, lifetime registration, although I think that's changed in Tier 3 because the Michigan Supreme Court said so, but I don't know if that has been changed. There's some controversy that there's some fight still going on with that, and I won't pretend I know every aspect of it. But in count 4, excuse me, the defendants won with the court saying that individual registrants did not have a right to get off the registry earlier, if I understand what count 4 says, and I think I do. Count 5, mandatory reporting requirements and compelled speech. This was a big deal, that the First Amendment was impinged, according to plaintiffs, that they can't be on any social media sites that they want, that they can't be involved in certain extra requirements that are put on them that would restrict the First Amendment. For example, in Virginia, we have to notify the state police that we're on all sorts of social media sites. I personally think that's an intrusion. That's none of their goddamn business. But the judges so far have been saying that they have a right to at least know what you're on. They don't necessarily have a right to all the content of it unless you're on probation, but they have a right to know what you're on in case there's further action against you. And some people think that's reasonable. Okay? And the court said that the state has a compelling interest in knowing that, okay, which is unfortunate because in some ways it is a First Amendment right that is being abridged by the state. But the court here felt otherwise, okay? Count 6, violation of plea agreements, okay? This is denied, it's moot because the court declared that retroactive extension of the registration terms violates the ex post facto clause, so you don't have to have any special plea agreements. It already is invalid, that the court had said. So count 1 effectively demolishes count 6, okay? and forced the state not to enforce it. Count 7, non-sex offenses, okay? Here the plaintiffs, the registrants, were granted summary judgment, in other words, judgment without further briefing, on count 7 as to their claims that 1, the claims required the individual to register as a sex offender. Listen to this. For those of you who think everything is fair and honorable and they believe in the Perry Mason and Boston legal justice system, if an individual is required to register as a sex offender when their offense did not involve a sexual circumstance, well, that violates the due process clause of the 14th Amendment. We have some places where if you're a murderer or there was a secondary sexual misdemeanor or something that was involved, maybe somebody was in a state of undress when you attacked them, okay, with a knife, well, that sometimes gets you a secondary classification and under law, but then also puts you on the sex offender registry. So, as I understand this, the plaintiffs are awarded that. They won that one. It does violate the due process clause of the 14th Amendment. The second point that the plaintiffs won under count 7 non-sex offenses is requiring an individual to register as a sex offender for an offense without a sexual element where there's been no judicial determination that their offense constitutes a sexual offense. In other words, the state said, well, you know, that you did something over there and they were in a state of undress, or they're just coming out of the shower when you attacked them, so we're going to add sex offense on top of that. And the court said, no, you can't do that. It's the court's job to interpret whether that was a sex offense or not. It is not the job of the state, okay? Clarifying important language, and that is an important element in the Sixth Circuit. Unfortunately, it only affects those 6 states, right? Michigan, Ohio, Kentucky, and Tennessee. Those 4 states in the Sixth Circuit, excuse me. Okay. Individual convicted of offense without a sexual element, including convictions, must be afforded a judicial or substantially similar conviction in other jurisdictions, must be afforded a judicial determination to see if that's a sex offense. So as I just indicated with the person who was in Kentucky, moved to Virginia, then moved to North Carolina, had to fight Virginia and North Carolina once they were off the registry because they kept being put on. That's not allowed in the Sixth Circuit. Now, of course, I say that this is a district court decision. It is likely that the state will appeal this if they haven't already. Why would they do that? Because they want to see it out and see if they can win. But as of now, as far as I know, there's been no stay on this. And if there is a stay and they lose at the Court of Appeals, that is, defendants lose at the Court of Appeals, this becomes a law unless, of course, they keep appealing it in some upper court, like the Michigan Supreme Court, reverses this district court decision. But this is an important step in the right direction. So, defendants, that is the state actors, are permanently also enjoined from requiring registration or enforcing registration against the Doe A, John Doe A, and non-sex offense subclass based on an offense where a sexual element, absent a judicial determination for their offense by its nature, constitutes a sexual offense under something else. So in other words, they are entitled to due process to have their claim examined by the court, have the claim of the state. If the state says, no, we're now going to make this a sex offense, you have a right for a judicial review, which seems fair to me. Okay? For members of a non-sex offense subclass who have both a non-sex offense conviction but another registrable conviction, defendants are permanently enjoined from acquiring registration. So in other words, again, any little thing where they can attach the word sex, the state will put you on a sex offender registry. Why would they do that? Is it just to protect the public? No, folks. They get a lot of money. The more of the federal sex offense registration requirements that a state adopts, the more annual revenue they get from the federal government. So they want, in some cases, to get all of them, all of these requirements in place, because if they can get, the more requirements they can get, the more beat down they can do on people like me, the more they look good, the more the feds are happy, and the more money they get. Everybody benefits except the little guy who's been slapped with a registration, particularly if they didn't earn it. Okay? This judgment does not bar defendants, reading point 5 here, from requiring registration and enforcing SORA without a judicial hearing against a subclass member with a non-sex conviction who also has a registrable Michigan conviction for a sex offense if defendants determine that the other registrable Michigan conviction for a sex offense results in Tier 3 lifetime registration. Okay? There are a couple other elements here too, but they talk about some other finer points, like if it's on the same date against the same victim. You know, those are exceptions, okay, to this judgment. All right. Let's see. They also talk about judicial hearing can be deferred until the subclass member is released from incarceration. However, he says, defendants are permanently enjoined, permanently blocked from requiring registration or enforcing registration against members of the non-sex offense subclass, this is reading on the bottom of page 5, who are serving a sentence in a state or federal correctional facility and do not have, top of page 6, another registrable Michigan conviction, absent a judicial determination of that, blah, blah, blah. All right, so they're not able to simply willy-nilly take somebody and who is in a state or federal correctional facility and say, well, they're more under our direct control, so we'll punish them and hammer them with more. They're not allowed to do that. Count 8, vagueness. All right, vagueness. Plaintiffs challenge certain provisions of SORA 2021 as unconstitutionally vague. Okay? And the judge says, look, we came to some consensus here. Where the parties agreed on a reasonable interpretation or a narrowing of constructions, that is definitions, that would resolve some of the plaintiff's allegations, the court adopts those interpretations. So he split it in part for the plaintiffs and, as you'll see, in part for the defendants. Where the parties did not reach agreement, however, the court ruled on the merits of those disagreements in its opinion and order regarding the plaintiff's motion for judgment. Both set of rulings are set forth below. Plaintiffs and defendants are both granted summary judgment in part regarding the vagueness issue. This seems like a very fair ruling where, very often courts have to balance competing interests. Defendants are enjoined from enforcing provisions that the court has determined are vague as set forth below. And I'm not going to go through all of these, but it talks about phone use, right? Because why do they go through all these definitions? Because probation officers with the Department of Corrections like to play games. Either they're told to, they're required to, whatever the reason is, there is a widespread argument among all sorts of people who are on probation for all sorts of crimes that they get nailed by the probation officer for all kinds of things. For example, they're told they could use a phone. They use a cell phone. They're arrested. Oh, I didn't say cell phone. I said phone. And, oh, I meant residential phone. So this is all determined here. All right. I heard numerous complaints from people when I was in jail that what they would do is you would get out, black males particularly, you would get out, you would call your PO within 3 days, and then you would not get a phone call back. you do this, one person told me, for almost 2 years, and then he stopped because he wasn't getting anything back. He didn't have any further convictions or whatever. One day they came by, they arrested him. Why? For absconding. Why? Because he didn't check in with the PO. But he never received a phone call back, and he showed me all the call logs, or what appeared to be call logs, right? Claiming, as he was going to see his attorney, right? That's why I had all this stuff, showing where he had called the same number over and over again and never got a call back. It was all outgoing calls, no incoming calls. And that's why he was in jail, for absconding, which is very serious. Absconding from supervision, right? Now, that is too clever by half and too devious by half. But this is what he's talking about, right? So it defines all of these things. Vehicles, it determines what owned is. It's a shame you have to define all these, but if the state didn't constantly violate these, then we wouldn't have this problem over and over again happening. Travel, temporary lodging. What's business days? Okay, what's 7 days? Is it 7 business days or simply 7 days, right? Let's see, any place of temporary lodging to be used by the individual during any period in which the individual is expected to be away from his or her residence for more than 7 days is vague, okay? Education, all right? The name and address of any school that has accepted the individual as a student that he or she plans to attend is vague. It sounds correct, but again, they're taking language out of a larger document, and they don't have the larger document here, but it references Michigan Comprehensive, I think, comp laws, whatever that means, 28.727, whatever, that's for people in Michigan to worry about. But I wanted to go through and look at alias and nicknames as well, all right? Physical descriptions. Substantial similarity with other people, right? Because there are mistaken identities, right? And then miscellaneous, okay? I love this one. A willful violation of the sex offender requirements does not include a failure to report information not required to be reported under this judgment, unless or until this judgment on count 3 is reversed. So what do probation officers in the state do? You have to do this. Well, you never said that. Well, you should know that. I said a complete reporting. So that's this new thing too that we didn't even know you had, but yeah, you had to report that. So in other words, they want you to report everything. Initially, I reported everything. Okay? Everything. But they have some weird requirements, right? They have requirements about, they wanted you to keep a masturbation journal. I refused. All right. They want you to keep what sort of sick person wants to be reading about your masturbation? Okay. It defies logic. The probation officer sat in my driveway screaming at me for an hour and a half because I had a friend who was trapped in the country staying with me due to COVID because he was in his 30s and I was 50. He was 35 and I was 50, and she was concerned about the age difference. Well, first of all, I told her there's nothing going on between us. Secondly, it's that he's an adult and so am I. And thirdly, it's none of her business. Okay? The charge had nothing to do with having sex with anybody who was over the age of 18. It actually had nothing to do with sex with somebody under the age of 18 either, as they said. But certainly, this would not be a compelling interest. And that's sort of thing that we have going on here, I think. Count 10. Reporting requirements restricting speech and association. See, when you get convicted of something and you lose your friends, the people you get to know are people who have been similarly nailed as you, whether it was fairly, honorably, rightly, or wrongly, whether you convicted properly or improperly, you get to know these people a little bit. Well, guess what? The probation officer says you can't be associating with any of these people. Okay? Well, how are you going to rebuild your life if you don't have social connections, which psychologists tell you are very important for rebuilding your life to avoid social isolation, whatever. And it is a tenet of the Department of Corrections to not only rehabilitate you, but punish you, right? They're very good at the punishing part. The rehabilitation part, they suck at. So here's a very important thing that will help you get rehabilitated, and of course, they restrict you. Let's see what the court said about this. Plaintiffs are granted summary judgment on count 10, which challenged the requirement to report electronic mail addresses and to report internet identifiers. So if you forget your work email, you can't be arrested and then fired. Okay? Requiring John Doe H and post-2011 subclass to report electronic mail addresses and internet identifiers violates the First Amendment of the U.S. Constitution. Woohoo! That's excellent. That's excellent. So you can't have any privacy according to these people while you're on the registry. Well, according to this, reporting your electronic mail addresses and internet identifiers. I assume that means being in a chat room or whatever, okay, that violates the First Amendment. So again, the court split the difference on First Amendment. You do not give up your First Amendment rights, particularly once you have done your debt to society. This idea of the registry being perpetual punishment has to end. Defendants are permanently enjoined from requiring other John Does to report electronic mail addresses or identifiers under Michigan laws, blah, 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 and from storing in the SOR database electronic mail addresses and internet identifiers previously reported by registrants, which have been stored in the database field for electronic mail addresses and internet identifiers. Count 11 non-Michigan offenses. I'm sorry, this is a little long and it's 31 minutes, but it's important stuff. If you have a offense from another state, plaintiffs are granted summary judgment on count 11 with respect to their claims. So if they are in the process of registering people with non-Michigan convictions, if those violate the due process clause of the 14th Amendment, then defendants can't do it. If they decide that when you cross the border, they're going to impose longer or harsher requirements on people with non-Michigan convictions than they do on people with Michigan convictions, that too violates the Equal Protection Law clause of the 14th Amendment of the U.S. Constitution. Defendants are also enjoined from requiring registration under SORA or enforcing SORA against select members of this subclass. It would be Ms. Doe, the one female, and John Doe G, and the non-Michigan offense subclass based on a conviction in another state. Okay? Notice to the class, prosecutors and law enforcement. Defendants shall, in other words, the state has to give copies of this to law enforcement and everything so that they are aware within 28 days of the judgment what they can and cannot do. Within 90 days, defendants shall update the explanation of duties, etc., so that everybody knows what it is they're required to do. Okay? And that there shall be within 60 days of the effectiveness of this, a class of this updated class list in an electronic format, and that the court will monitor it from here on out and how the record should be maintained. And let's see about attorney's fees and costs. Plaintiffs may apply for attorney's fees and costs. That doesn't mean they're going to get it. And there's a certain time period required to do that. And the judgment will take effect 90 days after entry, prior to the expiration of 90 days, unless Michigan enacts one or more new provisions of SORA. If any new provisions enacted within the 90-day period from the legislature, the effective date of this judgment will be 30 days from that. Okay, so in other words, give time for a new law to take place so that this can be on top of it, so that we know the chain of custody of when the laws and the court rulings occurred along the way. That makes perfect sense too. And that's basically it. Ordered by Judge Mark Goldsmith, District Court of the Eastern District of Michigan in the Lower Peninsula Eastern section. So I know this is a little long, but it's really, really important that you understand that. Now, what are the implications? A word or two about that. In the Sixth Circuit, which covers those four states, Michigan, Ohio, Kentucky, and Tennessee, This ruling is precedential. That is Precedential, has significance in that district. If it is upheld, if it stays on the books, if it is not overruled and reversed by an upper court. If that's the case, certainly the Fifth Circuit or the Fourth Circuit here in Virginia, which covers Virginia, Maryland, I think it is Maryland, the Carolinas, they can cite it, but it doesn't have the full force. It certainly is important, and a court may look at it favorably, and certainly that is the trend, although it's slow and lumbering, but it's something that we need here too, because the same games are being played elsewhere. And why are they being played? Because over and over again, government agents have learned that they will continue to press the envelope until such time as the court or the public reins them in. So with ICAC Unpacked on the 28th day of March 2025, this is Norman Michaelation. Have a good day.